do sentencings with a mask on, so I'm gonna take this thing off. Back on December 8th last year, the defendant entered into a plea wherein he pled guilty to count 2 as amended, arson of an occupied structure, a Class 2 felony in violation of ARS Section 13-1704A, committed on March 23rd, 2016, a non-dangerous, non-repetitive offense under the code. He also pled guilty to count 3, manslaughter, reckless, Class 2 felony, in violation of ARS Section 13-1103A1, committed on March 23rd, 2016, a dangerous but non-repetitive offense under the code. Since that time, I've read through the pre-sentence report, I read through the sentencing memorandum from Mr. Aldridge and all the letters attached thereto, and I read through the recommendation as to sentence from Mr. Chung on behalf of the state. I reviewed the plea agreement again. Mr. Chung, have victims' rights been complied with?
They have, Your Honor.
All right, are any victims or next of kin wanting to be heard today?
Yes, Your Honor. We
All
would
right,
ask
for
that.
those-
Oh.
Go ahead. Go ahead.
Oh, no, Your Honor. I didn't mean to interrupt you.
No, you're fine. What we'll do is, for those who are appearing virtually, if you could say and spell your first and last name so that the court reporter can get a good record of it, and then you're free to tell me whatever you want me to know, and we'll go from there. So who wants to go first?
I will, Your Honor. Maggie Badness, it's MAGGIE BADNAIS.
All right, thank you, ma'am. Go ahead.
I'm the youngest daughter of Joe Chenard, the man that was killed in the fire that Justin Caruso started. I just wanted to, initially I wanted Justin to burn in hell, but I no longer want that. I want him to be incarcerated for as long as possible, and I want him to be rehabilitated. I want him to feel remorse, and you know, I believe that, I don't know if he intended to kill my dad, but I do know that after my dad died in the fire that he started, he continued to start more and more fires. And so I feel like he wasn't remorseful, or he's maybe mentally, you know, mentally ill, and that he needs rehabilitation if possible, and he needs to be accounted for after he's released. I don't know if he can be rehabilitated, and I just feel like I don't want anybody else to get hurt by the actions that he causes. And we suffered a great loss losing my dad. He was a healthy man. You know, he was a good dad and a good grandpa. And he has a lot of great grandchildren. And we just, I know we kind of got robbed. And we want some justice. Thank you.
Thank you, ma'am. Anything else you'd like to say?
I guess, yeah, I will be praying for you, Justin, that you take advantage of all the services that are available to you while you're incarcerated. And I pray that you will not have to burden hell. I pray that you will be forgiven.
Thank you very much, ma'am. Anyone else who'd like to speak, Mr. Chung?
No, not that I'm aware of. Are there any other members of the family that would like to speak?
No.
Anybody else? No, thank you.
Okay. Mr. Chung, let me hear from you then.
Yes, Your Honor. Your Honor, can I have one moment, please?
Absolutely.
All right. All right, I'm ready. Your Honor, the state is is recommending that the defendant be sentenced to the maximum allowable sentence under this plea agreement, which is 18 years in the Department of Corrections. The state is also recommending that he be placed on 7 years of supervised probation upon his release. The state believes that this is an appropriate sentence due to the fact that the defendant, well, first of all, that Joseph Chenard is dead because of a fire set by the defendant, and that the defendant is a danger to the community as he is currently situated. The state believes that the defendant is a serial arsonist who victimizes the people around him and whatever community that he may enter. Beginning in November 2014 and continuing through January 2017, the defendant was linked to at least a dozen fires over 3 separate states. In May 2015, he set fire to his best friend's house in Yarmouth, Massachusetts, before moving out to Apache Junction, Arizona. In Apache Junction, defendant stayed with some friends until his car spontaneously combusted. The defendant then moved to Mesa in October of 2015, where the defendant was then linked to at least 5 different fires in the neighborhood where he and Joe Chenard both lived. After Mr. Chenard's death, the defendant then left for Texas, where he set fire to his friend's house in Austin. The defendant then returned to Massachusetts and set a structure in his brother's condominium complex on fire. The state presented evidence of these separate fires to an expert in serial arsons, Edward Nordskog. An analysis of those fires showed that the defendant demonstrates a pattern of ritualistic behavior with his fires. He often befriends his victims and assists them in any number of chores or tasks. And in doing so, he becomes familiar with their homes. After he sets the fire, he is then often the first person to discover the fire. He alerts other persons to the fire. In some of our cases, he asked someone else to call 911, and then he would respond to the same fire to render aid, conduct minor suppression actions, or even assist the victim in some manner. Following these fires, the defendant would interact with investigators, giving statements, and he would often post about the event in online forums or mentions to his friends about the fire. These common actions can be classified as ritualistic behavior that is fulfilling defendant's need to see himself as a helper or a hero. The defendant frequently mentions to investigators and others that he has relatives that are firefighters. The defendant stages his fires so that the cause determination is often frustrated or leads to a conclusion that the fire was accidental. The defendant has escaped prosecution and punishment for many years. Before this fire, the state is unaware of any individuals that were physically injured because of him. Nevertheless, the defendant's fires endanger everyone around him. And of course, this does not account for the psychological or economic toll inflicted upon the victims by having their possessions and homes destroyed by fire. The state does not believe that the defendant intended to kill Joe Chenard. However, there is no doubt that he set the fire on March 23, 2016, and that the death of Joseph Chenard is a direct result of that fire. Upon his release from incarceration, the state believes that an extended period of supervision is warranted to safeguard whatever community into which the defendant is reintroduced upon his release. Thank you, Your Honor.
Thank you, counsel.
Thank you.
Mr. Aldridge, I don't know if you want to go first or if there's anybody that wants to speak. I'll talk to your client last, but if you want to go first, you're.
Thank you, Your Honor. I wanted to find out, does Mr. Caruso, Justin's father, flew out from Massachusetts to be here, he's present. Did you want to address the court?
I'll try.
Okay.
I'll have you step over. Again, sir, if you could say and spell your first and last name.
Yes, it's Louis Caruso, Caruso. I'm Justin's dad. I apologize to Joe's family for what happened. And, I'm not really sure what Justin did or didn't do. I know there's a lot of evidence and circumstantial evidence and stuff, and I just know growing up that he's the sweetest, kindest kid. He was born special needs. He has mild Asperger's and stuff, and his mother died suddenly 8 years ago. And it seems like since that happened, he kind of started drinking a lot, became an alcoholic. We finally, after a couple tries, finally got him through a program. He did a 12-step program that he was in for 9 months. Got himself straightened out, was going to the AA meetings, had a nice apartment with friends, would always go to the meetings and helped other people in recovery and stuff like that. So, you know, I think what happens is when his mother died, whether it was PTSD or something happened in his, that made him cause him to just lose control with alcohol or anything else that he was happening. But I know growing up that he's the sweetest kid, would help anybody, and he certainly wouldn't intentionally try to hurt anybody. Thank you.
That's all, Judge. And then I'll.
Go ahead.
Speak.
You'd like to
May I
speak?
stay here, Judge?
You may.
Okay.
Hold on, just a minute. If we could mute the people online, just so we don't get the dog barking, that would be nice.
Sorry. Sorry.
That's okay. That's okay, Mr. Eldridge.
Thank you, Your Honor. Since Your Honor's decisions here, if we're following the plea agreement, are to impose a prison sentence on the manslaughter and a probation in the arson matter, we leave it to the court's discretion how much probation to impose on the arson. I really want to direct my contents to the prison sentence on the manslaughter, Your Honor. So Justin stands before you today facing conviction on his first 2 felony matters. And from the sentencing memorandum, the court's aware that he had some mitigation here. He's on the autism spectrum, has Asperger's syndrome. As I put it out, it did affect his. Sometimes it doesn't, but sometimes it does affect a person's ability to concentrate and retain information. Justin only has a 7th grade education, which obviously affects some of his ability to cope and other sort of choices. Additionally, Judge, he had a substance abuse problem. Drinking was his problem. He's taken steps to get that under control, but it seems like even on the night this was happening, there was alcohol involved. As you can tell from the letters, Your Honor, and his father's been in constant contact with myself and Mr. O'Sullivan, wanting, updates, asking questions, doing everything a diligent father would do in a case like this. He has huge familial support. Most of it's back east, back in Massachusetts area, from his brother, his father, his uncles. A lot of family out there provide familial support for him. He is remorseful, Judge. He never had any animosity towards Mr. Chenard. In fact, Mr. Chenard was drinking beers with Justin, his roommate, prior to the fire being set, and all 3 rushing over there to see the fire, and Mr. Chenard running in to get the car keys, move a car, and although it's foreseeable that doing something reckless and dangerous like starting a residential fire could result in serious physical injury or death, Mr. Caruso never had any intention to harm Mr. Chenard physically at all. Now, maybe the harm there was harm, obviously economic, to whatever happened to his house, but he was never intending to harm Mr. Chenard. He is remorseful for his death. I'm being reminded that one of the facts were in the discovery, he advised Joe not to go into the trailer, not to go into the home. I'd also mention, Judge, that having pled guilty to such serious offenses, he has accepted responsibility for his conduct in this matter. And with regard to that, I know that you've heard the state make the statement about other instances and things like that. And I know the court has great discretion to consider a broad array of information when determining sentence. But with regarding the weight to give those other instances, we had a 404B hearing, Judge, in front of Judge Mraz. 14 other instances were mentioned. Judge Mraz let 8 of the other 14 in under very narrow circumstances to prove identity or signature, because identity was an issue in this case. In those others, there's one other case out of Texas where there's a video that's in dispute. From the state's perspective, they would say it conclusively shows Mr. Crusoe started the fire. From the defense perspective, it's more equivocal. We're not sure that it really shows that. But in all the other instances, there's no direct evidence tying in. There's no confession, there's no video, there's no fingerprints, there's no witnesses, nothing that directly ties Mr. Crusoe to these instances. All that there is primarily is his proximity to these other fires. And I know the prosecutor mentioned their arson expert. Well, the court, again, doesn't have the arson expert's report in front of it. You're just sort of hearing secondhand from the prosecutor about it. So, Your Honor, we would ask the court not to give much weight to these other instances because they were not proven. It's doubtful they could ever be proven. And as I said, Mr. Crusoe stands before you convicted of his first offenses in this matter. And what we're talking about here, if we back up a little bit, we're talking about the difference. He's already pled to an aggravated range on his first felony matter. The presumptive term of manslaughter is 10.5 years. So we're talking about a range of 15 to 18 years. We're already deep within the aggravated range. We're not at the top at 21, but we're certainly not at the bottom at 10.5 or 11. Whatever the court decides is an aggravated term of imprisonment. And because of Justin's mitigating factors, because of the fact that these are his first felony offenses, because of the fact that he had no intention to harm Mr. Chenard, although his conduct was reckless and did result in Mr. Chenard's death, unfortunately, we would ask the court to impose a prison sentence of 15 years.
Thank you, counsel. Anything else?
No. Your Honor, may I make one brief comment?
Sure.
The only thing I would add to that is, in addition to it, the sentence inherently being an aggravated sentence, even if Your Honor was to give the low end of the range, the 15 years, in addition, Mr. Caruso has agreed to a probation tail, a term of supervision following his release from the Department of Corrections, which, as Your Honor is well aware, will carry a significant additional prison sentence if Mr. Caruso does not abide by the conditions of probation. Mr. Caruso was willing. In fact, we proposed a probation tail, knowing full well that if unsuccessful, it would carry additional prison time. I think that is important to consider when determining the length of the prison sentence. As Mr. Aldridge stated, it's already inherently an aggravated sentence, but additionally, he will be coming out on a probation tail with additional prison time hanging over his head.
Thank you. Sir, now's your opportunity to tell me whatever you'd like to tell or say whatever you think you need to say.
Well, you heard it from my father, you heard from my attorney, but I did write something, but it pretty much says everything that they said, but I'll go ahead and read it anyways. This letter just shows the true me, the true me and not a bad guy, but a loving, caring, kind-hearted person. My name is Justin Crusoe. I was born in 1685 and lucky to be here. I was born a blue baby in C-section. Due to being that I have what is known as Asperger's, it is a form of autism. In this letter, I'm not trying to make myself look like but no one in life is perfect. Being born special needs, I have challenges and pain and heartache. I was born in Cape Cod, Massachusetts, but being born special needs did not stop me from having stopped me from having a great life. My only downfall I had was being bullied in school, mentally and physically, from childhood on. I had a loving family. I had a loving family, though, and a few good friends. In 7th grade, though, things changed. My vice principal, in a way, assaulted me, and I left school. At the age of 16, I went to a private school for special needs until I was 19. It was not fun being away from my family. Because growing up, we went to Florida from when I can remember all the way up until my late 20s in my life. When my mother passed away, I started drinking a lot more. And soon I found I could not stop. And I got help. And I went into a program, a sober house. But when I left later on, I relapsed because they did not teach me the 12 steps. So I found a place on my own called the Brook Retreat. I knew if I kept drinking, I would probably be dead. After my call, I moved into the 12-step sober living, nothing like they have in the state of Arizona. I moved in on 6/10/2019. I worked out in this house, and plus I made the call. I found a higher power and a fellowship only a 12-step house can do. I've gone into an amazing guy from the letters you have read from my friends, family, and coworkers, and people I've helped to get sober. With my recovery, I've helped hundreds of people from speaking at jails, detoxes, recovery centers, about recovery in the 12 steps, and how it has changed me into a much better person. I've lost a lot of friends due to this illness. I just hope, Judge, when I get to DMC, I can still do what I did on the outside, and that is to keep helping those struggling with this illness called alcoholism. And I accept whatever punishment you deem fit, because I have my sobriety and my faith to make it to the end. And to the family of Joe Chenard, he was an amazing guy, and I learned a lot from him, and he truly will be missed. And I thank you.
Really sad because he got caught.
Court finds that there are some mitigating factors. There is remorse. There is love of and love from family. However, there are more aggravating factors. Specifically, the court finds that, first of all, the victim who died was over 65. The victim suffered death by fire, so he clearly suffered physical harm. The victim's family suffered emotional and financial harm. The use of fire is a deadly weapon or dangerous instrument during the commission of a crime. And although I, too, believe that you did not intend for Mr. Chenard to be killed, the starting of a fire in a residential property could lead to that result. And in this case, unfortunately, it did lead to that result. So the court finds those aggravating factors outweigh the mitigating factors. The court also believes that those aggravating factors justify a greater than the presumptive sentence, but less than the maximum, which is what the range of the plea agreement is. Given your history and what I've read, it seems like there are some mental health issues, it could be an issue. However, there's also a need to protect society. And so the judgment of the court will be for a sentence of 18 years, and it will be for a probation tail of 7 years thereafter. I've got to read to make it all official, and that's what the judgment's going to be. So let me read it. It is the judgment of the court that defendant is guilty of count 3, manslaughter, reckless, class 2 felony, violation of ARS section 13-1103A1, committed on March 23rd, 2016, a dangerous but non-repetitive offense under the code. As punishment, it is ordered sentencing the defendant to the term of imprisonment and committing him to the Arizona Department of Corrections for a less than maximum term of 18 years to begin today, with a pre-sentence credit for 688 days time served. Counsel, is that the days you have?
Yes, Your Honor.
Mr. Chung, is that the same you have?
Yes, Your Honor.
Community supervision will be waived because of the probation tail on count 2. There are fees and fines associated with this offense. There's a $2 victim rights enforcement assessment, a $20 time payment fee, and a $13 criminal penalty assessment to the Mesa Police Department. All of those will begin to be due on the first day of the 4th month after your release from prison. I'm going to keep restitution open for the length of the prison term. If the restitution hearing is held, does your client want to be present?
Mr. Caruso, do you want to be present, brought back from prison, or do you just want me to handle the restitution hearing without your presence? I can keep you advised what's going on, but
Oh, it's all right.
you want to come back?
Oh. No need for it then. Yeah.
You waive your presence?
Yeah.
Okay, we'll waive your presence.
Okay, defendant waives his presence at any restitution hearing. We will order the sheriff's office to deliver you to the Department of Corrections to carry out this term of imprisonment. We'll also order a copy of this order of confinement, and all other unsealed pre-sentence reports be delivered to the Arizona Department of Corrections. It is further the judgment of the court that defendant is guilty of count 2 as amended, arson of an occupied structure, class 2 felony in violation of ARS section 13-1704A, committed on March 23rd, 2016, a non-dangerous and non-repetitive offense under the code. The court will suspend imposition or execution of the sentence and place you under the supervision of the Adult Probation Department for a period of 7 years of supervised probation upon your release from prison in count 3. You are not allowed to return to the scene of the crime. You do have to pay restitution for all economic loss to all victims, and you can have no contact with the victim's next of kin. There are fees and fines associated with count 2. There's a time payment fee of $20. There's an extradition cost of $6,496.51. I'll order you to pay $50 a month towards that. There's a probation assessment of $20, criminal penalty assessment of $13, a victim rights enforcement assessment of $2, and a monthly probation service fee of $65. All of those will begin to be due on the first day of the 4th month after your release from prison. We will dismiss counts 1 and 4 and all allegations listed in paragraph 3 of the plea agreement. Other than the PCR information, Mr. Chung, have I missed anything?
No, Your Honor.
Anything else you need to say on behalf of the state for the record?
No, Your Honor. Thank you.
Mr. Aldridge, have I missed anything?
I don't believe so, Your Honor.
Is there anything else you need to say for the record for defense?
No.
Okay. Sir, you have the right to file what's called a petition for post-conviction relief, but you have to do that within 90 days from today or you lose that right. If you can't afford an attorney, one will be appointed for you. If you can't afford the cost of papers or transcripts, those will be produced to you at no charge. After you complete the term of imprisonment and the length of probation, you'll have the right to ask the court to set aside the judgment of conviction if you qualify. You'll also have the right to ask the court to restore your civil rights if you qualify. But I will leave it to an attorney to explain to you whether you may or may not qualify for those rights given the nature of these crimes. So what'll happen now, sir, is I'm going to look through this on the computer up here and make sure it says what it's supposed to. When it does, I will sign it electronically. And it'll go over there to my staff. They'll have you sign a few documents electronically. They'll get some fingerprints from you electronically. And at that point, the deputy would take you back into custody. You'll be processed and eventually delivered to the Arizona Department of Corrections to carry out your term of imprisonment. Do you have any questions?
No, Your Honor.
Put my mask back on. Counsel, if you guys can stick around until I get this done, that would be great. Yes, Your Honor.
Ms. Vadnais, our office will be in contact with you to follow up if you have any questions about this, okay?
Okay, and I want to thank you, Mr. Chung. And Your Honor, I want to thank you and Detective Amy Johnson. Thank you for all your hard work.
Okay, it looks correct. I'm signing it right now. All right, it is signed. At this point, we are adjourned and I will go off the record. Thank you all very much.
Thank you.
Thank you, Ms. Vadnais.
So